Assalamualaikum warahmatullahi wabarakatuh to Madam Muna Farhana. Today, I, Muhammad Rahimi bin ZAHRUL-LAIL, with my teammate, we're going to present about discharge of contract and remedies for breach of contract. My teammate is Henry SUFI bin ISKANDAR ZULKARNAIN Lim, and the second is Muhammad Iman Haziq bin RAZAK, and the fourth person is Muhammad AKID FADLIN bin SHAHROL. And I'm going to present about the discharge of contract. Discharge of contracts means that the contract has come to an end, and the parties to an agreement are free from their contractual obligation, and neither party has any further obligation under it. And there will be 4 ways in discharge of contract. The 4 ways is discharge by performance, discharge by agreement, discharge by frustration, and discharge by breach of contract. Discharge by performance. These are usually methods for the discharge of contract, and the parties to the contract perform the duties completely. The performance must be exact and precise, and in accordance with the terms of the contract. In Section 38(1) of Contract Act 1950, they said the party to a contract must either perform or offer to perform their respective promises unless the performance is dispensed with or excused under this Act or of any other law. Next, we go to discharge of agreement or consent. If either by express or implied consent, the consent of all parties to the contract is necessary. But in this discharge, there are occurs in various situations. For example, is waiver, release, novation, remission, or rescission. Waiver. Waiver, a process of giving up any right on anything with a voluntary action or non-action. Waiver of a right can be temporary or permanent nature. Next is release. Release is freeing from an obligation or commitment or liberating one from a duty or claim that she could have been held legally liable for. Next is novation. Novation is the substitution of a new contract for an earlier one, particularly a contract between a creditor, a debtor, and a third party, whereby they agree to substitute a third party for the debtor under the original contract, which will be discharged. And next, we go to remission. Remission, discharge or release from penalty or obligation. And last but not least is rescission. This is available when fraud, a mistake, duress, or failure of consideration is present. Among all of these situations, there are effects on novation, rescission, and alteration of contract. The effect is Section 63 of Contract Act 1950. If the party to a contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. And next, we go to Muhammad AKID FADLIN to present about discharge by frustration.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad AKID FADLIN bin SHAHROL. I'm from class 10 6B, and I am the second presenter for this presentation. Okay, the next one is discharge by frustration. A contract is frustrated when there is a change in the circumstances which renders the contract legally or physically impossible of performance. In Section 57(1) of Contract Act 1950, an agreement to do an act impossible in itself is void. There are four circumstances of impossibility of performance. Number one is destruction of a subject matter of a contract. This means when a contract depends on the existence of that thing, but the thing was destroyed, and that are the first circumstances. And number two, where is a contract depends on the happening of the certain events. This means if the event does not occur, the contract is discharged by frustration. Number three, supervening illegality. This means when the contract becomes illegal. Example is when the outbreak of war in certain country. For the last circumstances, which is death or personal incapacity, the contract is discharged on the death or incapacity or illness of a person if the performance of a contract is depend on his personal skills and ability. Next one is discharge by breach, when one of the party fails to perform his obligation. And next one, indicate the other party an intention not to go on with the contract. The party is said to repudiate the contract. The disability to perform is due to the fault of the party concerned. There is a three forms of breach, which are: number one is refuse to perform, number two is disable himself from performing promise, and the last one is repudiated liability under contract. For the effect of breach, an innocent party may put an end to the contract and must restore any benefit which he may receive from the other party stated in Section 65 of Contract Act 1950. That's all from me, and I'm moving to the next presenter. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Iman Haziq bin RAZAK from Den 6B. So today I will continue the presentation for my group, which is remedies for breach of contract. Before we proceed to the next slides, let me tell you first about the definition for remedies for breach of contract. The definition means a right that can be claimed by a party to a contract that experienced losses because other party to the contract was in breach. There are four types of remedies, which is damages, quantum merit, specific performance, and injunction. But today, I will be only present about two types of remedies, which is damages and quantum merit. We go to the first types of remedies, which is damages. Damages is defined as the cost estimated compensation in money for detriment or injury sustained by the plaintiff in contract or tort. The section is Section 74 of Contract Act 1950. There are two types of damages, which is natural damages and special damages. Natural damages is defined as damages arising naturally and directly out of the breach in the usual course of the things, while special damages is indirect results of an injury which do not necessarily result from such an injury. They are aim of rewarding damages, which is to give relief to the innocent party for the losses incurred, not to punish the party who is in breach. We go to damages of unspecified amount, which is there are three of them, which is substantial, nominal, and exemplary. Firstly, substantial. Something substantial is large in size, number, or amount. If you want to say someone spent a lot of money without being too specific, you could say they spent a substantial amount of money. Secondly, nominal. a very small amount which is much less than something is really worth. Transport can be provided for a nominal sum. And thirdly, exemplary. Exemplary is an amount of money that someone who commits an offence has to pay, which is intended to be large enough to prevent them or others from committing similar offences in the future. The second type of damages is quantum merit. Procedurally, quantum merit is the name of a legal action brought to recover compensation for work done and labour performed when no price has been agreed. The term literally means as much as is deserved and often can be seen as the legal form of equitable compensation or restitution. For example, in construction contract, additional expenses by the contractor due to a significant change in the quantity of the work which was supposed to be carried out and paid accordingly. That's all from me. Thank you very much.
Assalamualaikum and a very good morning to my lecturer, Madam Muna Farhana. My name is Haziq. Now I'll proceed with the other two remedies for breach of contract, which is the specific performance and injunction. Specific performance is a court order directing a party to perform the terms of contract, which means to do exactly what the party has promised in contract. According to Section 11, Subsection 1 of Specific Relief Act 1950, specific performance may be granted by the court in the following circumstances. First one, the contractual obligation is a trust. Second, actual damage cannot be ascertained. Third, a breach cannot be adequately relieved by compensation of money. For example, an art collector promised to sell one piece of art collection to Mr. White, and they had made a legal sales of contract. But the collector then decides to keep the art for now. In this case, the collector had breached the contract with Mr. White. The court then decided that the piece of art is truly priceless and Mr. White can't acquire another comparable piece no matter how much money the court awards her. Instead, the court decides that the collector should comply with the terms of contract and sell the piece to Mr. White for the price he already agreed in the contract. That's for the specific performance. Now let's move to the injunction. As you can see here, injunction is a court order compelling an individual or entity to do or to refrain from doing a specified act. According to Specific Relief Act 1950, injunction is a remedy class in Part 3 as the preventive relief. And for information, preventive relief is a relief where a party to the contract is prevented from doing a particular act which he is under an obligation not to do. And according to Section 50 of Specific Relief Act 1950, preventive relief is granted at the discretion of the court by injunction, temporary or perpetual. As you can see on the slide, there are two types of injunction. The first one will be temporary injunction, and the second one will be perpetual injunction. Let me explain about temporary injunction. Okay, temporary injunction are such as are to continue until a specified time or until the further order of the court. They may be granted at any period of suit and are regulated by the law relating to civil procedure. For example, A. File a suit against B for declaration of title and recovery of possession of immovable property. There were some trees on the property. A. File a petition to court for an injunction against B to restrain him from cutting these trees. This for the temporary injunction. Now for perpetual injunction, can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of plaintiff. For example, A, B, and C are partners, and the partnership being determined at will. A threatens to do an act sending to the destruction of the partnership property. B and C may, without seeking the solution of the partnership, sue for an injunction to restrain A from doing the act. That's all for the injunction. And that's all from us. Thank you.